Ma'am, because partnership generally has a role where we have to take up a business and precisely we have to share the profits. Whereas in a joint ownership of property, the owners have to share both profit and losses.
Uh, See, in the partnership also, see, the intention is to share the profit. That is an essential element. But when there is a loss, then obviously the partners are going to share the loss as well. Okay, so in co-ownership, that is not the reason. That's not the only reason because of which we are saying that okay, co-ownership. The major difference is one that in co-ownership you can say that this rent is also share of profit only, right? In a way. So if suppose if they are but what is the intention that is they are carrying any business?
In joint ownership, no, ma'am.
Yes. So the intention has to be seen that in future they intend to carry on. In the future also the intention is to carry on business or not. So suppose if this the same property, uh, if the same property is co-owned by two brothers, and this they decide to make it as a hotel, and in day to day life they are investing money also. They are doing some advertisement for running that hotel. And just give me okay, what do you think, that is that a co-ownership of land or it is a partnership business? Give me just a minute.
Ma'am, it is a partnership business.
Yes, it is a partnership business because we have to see the intention. It is not necessary that the partnership is only through an agreement. Uh, it may be implied also. Yes, okay, better. So now we'll move ahead. Uh, have you read section 6 or we have to do it? आप लोगों ने सेक्शन 6 पढ़ लिया है क्या? Okay,
Ma'am,
let's
I have not read.
let's go through it quickly. In determining whether a group of person is or okay, is not a firm, or whether a person is or is not a partner in a firm, regard shall be had to be the real relation between the parties as shown by all the relevant facts taken together. So that's what we are just discussing about. Okay, explanation 1: the sharing of profits or of gross return arising from property by person holding a joint or common interest in that property does not itself make such persons partner. This is about the co-ownership, which I have given you an example. So if the person is just having a common interest in that property and from that he's receiving any kind of profit or gross return, that does not make them partners. But however, if they are doing a conduct in such a manner that that they are carrying on business, then then it is a partnership. Okay. Explanation 2: the receipt by a person of a share of the profits of a business or of payment contingent upon the earning of profits or varying with the profits earned by a business does not of itself make him a partner with the persons carrying on the business. So, what is this? Contingent upon the earning of profit or varying with the profit earned by a business. Okay, so say if I give you an example, that is some person, say your creditor, um, said that ki, okay, I will take 12% interest on the loan amount as well as 5% on the profit earned. Okay, so this creditor is sharing certain profit in your business. That doesn't make them a partner. Okay, or if their payment is contingent upon earning of profit, say if they are saying that ki, okay, you pay the interest amount only when you earn the profit. or varying with the profit earned by a business. This is a 5% which I am saying about. So does not of itself make him a partner with the person carrying on the business. So just only by sharing of the profit does not make them a partner. And in particular, the receipt of such share or payment by a lender of money to person engaged or about to engage in business, the example which I gave you, by a servant or agent as remuneration. So say if a chartered accountant has been hired by a company, and the fees is like the company has decided to give a certain no remuneration to a chartered accountant, and also decided that if he's giving certain ideas, or no, finding out certain fraud or something like that, then his revenue is also includes certain percentage from the company profit, the enhanced amount which is contributed because of his performance. So even if that is there, then also it is not amounting to him as a no, partner of the company, of firm, I mean to say partnership firm. Okay. By the widow or child of a deceased partner as annuity. Okay. So I in first class we have discussed that in partnership, the partners are selected by choice, right? Just not by, if somebody died, suppose Mr. A as a partner died, that doesn't make his son be a partner in the company, in the partnership firm. Okay. Or his widow as a partnership, as a partner in the firm. But through a partnership agreement, they might be receiving an annuity. So this annuity will not considered as a share of profit, or you will not consider her or the child as a partner of the firm. By a this exam For this, I think there is a judgment recently came also. Please try to search. There is one judgment recently in 2025 itself, wherein I think one hotel business or something is there, wherein the son of the deceased was claiming that property back. And in that judgment itself, discussion about annuity is also given. I mean, judgment regard to annuity has been given. Okay. By previous owner or part owner of the business as consideration for the sale of goodwill or share thereof. Okay. So this is about the okay, that the goodwill it has been purchased, and on that a share of profit has been given. So that also doesn't make them that person as a partner of the partnership firm. Okay. This we have already discussed. See, if any in any partnership agreement, if suppose uh, the mode of determination is not mentioned as a time, like it has been mentioned that the firm will come to an end when it will reach to a certain target, say 1 crore or turnover. So it is a mode of determination that the partnership is for that duration. Okay. It is not necessary that it is to be only a 5 year or certain time has to be mentioned. The determination can be also depending upon certain the fixed duration can be mentioned on certain determination. Okay. Like revenue or any other uh, they want to have a trading relation in some country or something, like any kind of determination they mention that it will be the final determination on this. If once we partnership firm is going to achieve that, then it will end. So that can be possible. So it is written in the partnership at will, where no provision is made by a contract between the partners for the duration of their partnership or for determination of their partnership. So determination of their partnership is like this, the example which I have given. The partnership is partnership at will. So if the duration is mentioned in the partnership agreement, or any kind of determination is there for making the relationship of partnership, then uh, then it is not a partnership at will. But if both is not there, then only it is a partnership will at will. Okay. And in case of particular partnership, I have mentioned that it is for a particular undertaking. But however, if you have mentioned, if you can see in the definition, it is mentioned about particular adventures. So what do you mean by particular adventures? Is it some kind of bungee jumping, or some kind of roadies, or what?
Ma'am, some kind of joint business like future planning, something like that.
Yes, any kind of particular project which they are planning of. So anyways, any kind of business which the persons do, they must be they might be a risky one. So they might make it, they may not make it. So they that's why it is called as an adventures. It is not the literal meaning of adventure. Okay, now we'll move to relation of partner to one another. Okay, section 9, general duties of partners. Partners are bound to carry on the business of the firm to the greatest common advantage, to be just and faithful to each other, and to render true accounts and full information of all things affecting the firm to any partner or his legal representative. So, if you go through it, it it is saying no that all these are absolute duties of the partners. So even by the expressed term it cannot be changed or varied. Okay, so they must be working for the firm, for the common advantage of the firm, and they must be just and faithful to each other, and they must be no rendering true accounts and full information of all the things affecting the firm. Okay, so if I say that, if I give you an example that ABC is doing a business of some diamond, in which Mr. A has knowledge about diamond, but B and C are not. So if A went to buy ABC went to buy uh, certain stock of diamond from a store, and they found that Mr. A found that it is of less quality, and B and C couldn't able to find it out the difference between the no whether it is a superior quality or less quality, to identify the price. Okay, so B and C agreed to pay the price what of the superior quality which the which the seller is saying. But since A is aware about it, so it is his duty to provide a full information of all the things, because it is going to affect the firm, right? uh, Section 9, duty to indemnify for loss caused by fraud. Every partner shall indemnify the firm for any loss caused to it by his fraud in the conduct of the business of the firm. So, suppose in this example itself, Mr. A has no, has done some collusion with the seller, and he said that, okay, I will not inform my other partners, and whatever the amount you are getting out of it, like from selling the lesser quality diamond at superior price, so the difference amount we will share it. So now this is what fraud, right? So it is a fraud in the conduct of the business of the firm. So that the person who has made this fraud has to indemnify that loss amount. Okay, similarly it is any number of partner or all the partners. Determination of rights and duties of partner by contract between the partners. So this is not, it is not an absolute duty. Okay, this is happening by contract. So it might be there, this right and duties might be there and might not be. Okay, subject to the provision of this act, the mutual rights and duties of the partner of a firm may be determined by contract between the partners, and such contract may be expressed or may be implied by a course of dealing. Such contract may be varied by consent of all the partners, and such consent may be expressed or may be implied by course of dealing. Okay, I hope it is clear. Notwithstanding anything contained in Section 27 of the Indian Contract Act 1872, such contracts may provide that a partner shall not carry on any business other than that of the firm while he is a partner. See, it is mentioned in Section 11, okay, which is not an absolute right and duty. So it is only by the express agreement that the all the partner decided that they agreed that all this they will not carry on any other business than what is there in the firm. Okay, but if such expressed contract is not there, then whether they can do that for business or not. and this is non-obstante clauses. Okay, so it means that whatever in the section 27 of the Indian Contract Act says, it is not going to apply in this particular act. Okay, so what it is that nobody should be restrained to do a lawful trade, occupation, or business. That what it mentioned in section 27. Okay, so however, what it is happening in the Partnership Act, it is mentioned that by an express contract, the firm can restrict the partners to not to carry on any business, and that business must be a lawful business. Obviously unlawful business it is not saying about. So they are not they through an express agreement, even the lawful business can be restricted. Okay, and even they restrict that they will not be any of the partner will not be an employee of any company, or they might not be carrying on any business, not necessarily the same business which the firm is carrying on. Okay, section 12, conduct of the business. Subject to contract between the partners, every partner has right to take part in the conduct of the business. Why it is mentioned as subject to a contract between the partner? Every partner has a right to take part in the conduct of the business.
Yes, ma'am. So, with the ma'am, like how we can lawfully we can restrict even a lawful business due to this partnership. There can be like some rights that is exclusive to these two partners only, and some rights that are like cannot be granted generally.
Yes. So we have discussed about active partner, sleeping partner. We have seen that if nothing is mentioned in the agreement, then it is that every person, every partner is entitled to have have to manage the affairs of the firm, and look after the conduct of the business. But if it is through contract, express contract between the partners, it can be restricted, that particular Mr. A being a partner only is going to look after the have all the authority to have a bank account dealings and borrowings and the conduct of the business, and the rest might not be. So that can be possible. Every partner is bound to attend diligently to his duties in the conduct of the business. Why it is subject to contract? Because suppose a sleeping partner is there. So if the sleeping partner is not necessary, is not required to look after the conduct of the business. So so the person who are active, that partner is responsible for the conduct of business, and he has to attend everything diligently. See, any difference arising as to ordinary matters connected with the business may be decided by a majority of the partners, and every partner shall have the right to express his opinion before the matter is decided. But no change may be made in the nature of the business without the consent of all the partners. So this is very, very important. What it says about two things. One is about ordinary matter, and another is about no, nature of the business, the matter which is related to the nature of the business. Okay, in case of ordinary matters, any kind of no anything is decided, any difference arising as to ordinary matter must be decided by the majority of the partners, and not necessary it has to be all the partners. So in case of ordinary matters, like instead of buying it from ABC limited, let's buy it from XYZ limited, all the stocks or the purchasing materials, or in the same example, the trading of diamond. So in that case they decide that okay, this creditor we are not going to deal, we are going to deal with another creditor. So this is an ordinary matter of the business, and this can be decided by majority of the partner. Even if one or two is not agreeing and five is agreeing, then the majority lies on with the five partners, right? And every partner shall have right to express his opinion before the matter is decided. However, all the partners who are assenting with regard to that decision, or who are dissenting with regard to that decision, has right to give his opinion. Okay, the person cannot be the two person who are not uh, agreeing with the decision that there should be a change with regard to the creditor or this seller. um, they cannot be mute. uh, her his or her opinion has to be recorded, if that is no if they want to express their opinion, it is they all the partner has to hear it. But no change may be made in the nature of the business without the consent. So now they are doing the trading business. But if suppose they decide that the rest of the five people, they decide that we want to enter into manufacturing business, or we want to open another business like a hotel business. So this is a completely change of business. It is a very substantial matter, which has to be decided with the consent of all the partner. Even if one is not agreeing with it, the change in the nature of business not possible. Every partner has right to have access to and to inspect and copy of any of the books of the firm. It is about books of accounts that all the partner, whether it is a active partner, sleeping partner, nominal partner, we have discussed now, type of partner, every partner has right to access that. Okay. Mutual rights and liabilities. Subject to contract between the partners, a partner is not entitled to receive remuneration for taking part in the conduct of the business. First of all, tell me, what do you think, that partners are employee, or they are not an employee? Are they employee
Ma'am,
of the firm?
ma'am, I don't think they are employees.
Yes, they are not. They are not an employee. As we have discussed about proprietorship concern, one person owns that proprietorship. Similarly, the firm, all the partners are cumulatively called as firm. So they are the owner of the firm. They have dual role, principal as well as agent, like so mutual agency is there. But they are the owners only, so they are not an employee. But since that's why it is mentioned that subject to a contract between the partner, a partner is not entitled to receive remuneration for taking part in the conduct of the business, but they are entitled to share the profit of the business, right? Which we have discussed. However, why it is mentioned as subject to contract? So it means that by contract, they can even assign themselves remuneration. Okay. Even in case of proprietorship concern also, proprietor if want to draw remuneration from the undertaking, that person can do that, in proprietor can do that also. And even it's not necessary only by the contract, it even by the usage, like the customs prevailing at that area, no, that in during in that business. So if that custom or trade usage also says that the partners can draw remuneration, then also they are entitled to do remuneration. Okay. That's why it is mentioned subject to a contract between the partner. The partners are entitled to share equally in the profit earned and shall contribute equally to the losses sustained by the firm. So if nothing is mentioned in the partnership agreement, that how the percentage, how the profit will be shared between each other, then and how the losses will be shared between each other, then in that case it will be shared equally. But if suppose profit sharing is mentioned but not the loss sharing ratio, proportion is not mentioned, that it will be shared in the same proportion as the profit is shared, the loss will be shared in the same proportion. Okay. Where a partner is entitled to interest on the capital subscribed by him, such interest shall be payable only out of profit. um, about the It is about the interest. Okay. Partner making for the purpose of the business any payment or advance beyond the amount of capital he has agreed to subscribe is entitled to interest thereon at the rate of 6% per annum. So it is subject to a contract. It's not necessary that he has to only give that loan. Advance means like what? The partner is providing certain amount, no, as an advance, as a loan to the partnership firm. So on that, he's not only entitled to have a 6%. This is a minimum cap provided by the act. Okay. So but it can be varied, like it can be even no interest also. It is not necessary. If in contract they mention that keep on advance also they don't want to take any interest, that is fine. Or they want to higher it, it's upon them. But on the dissolution of the firm, interest on capital will be stopped. But even after the dissolution of firm, and if the advance amount has not been written, then it will be the interest on advance will be even again accumulated until it is paid. the advance amount is returned and the interest amount will be paid. Till then, the interest will be accumulated over it. The firm shall indemnify a partner in respect of payments made and liabilities incurred by him. Okay, this is very, very important. See, what it is saying, that earlier we have seen that when the partner is indemnifying the firm, right? This is about the firm is when the firm is indemnifying a partner. So it is about that. So suppose a partner, say I being a partner of a ABC firm, in that I went to shop certain no purchase I went to purchase certain goods for the for the partnership firm, and I there is certain amount which is less what is provided to me to buy. And in this is an emergency situation wherein the that good is very much important, otherwise there will be a loss to the firm. So in that scenario I have paid the rest of the amount. So in the ordinary and proper conduct of the business only I have paid that amount from my own pocket. Now the firm is duty bound to indemnify that amount to me. Okay, in doing such act in an emergency for the purpose of protecting the firm from loss. So see, earlier example, if there is not an emergency and I have not been having any amount, but I similarly went and buy a certain good because I found it is at less price and the firm will be getting benefited, and the same good the firm is in trading business. So it is an ordinary and proper conduct of business. At that moment also the firm has to indemnify me. And similarly, the example which I have given in an emergency situation, also for the purpose of protecting the firm from loss, as would be done by a person of ordinary prudence. In an ordinary prudence, the partner would have paid that amount, right? Because if that is not provided on time, then there will be a halt in the manufacturing and there will be a loss. So in that scenario also, if partner has paid that amount, then the firm has to indemnify it. Okay, these are the only two scenario in which the firm shall indemnify, and not in any other scenario. A partner shall indemnify the firm for any loss caused to it by his willful neglect in the conduct of the business of the firm. Okay, earlier we have mentioned about the fraud. Now here it is saying about willful neglect. So what do you mean by willful neglect as a layman?
Ma'am, neglecting something that was due. For example, I can give an example where, for example, there is a person who bought a good and he forgets that I have purchased this in the name of the firm and I have to complete the payment. So this is his negligence.
Mm-hmm. Correct. Very correct. So suppose on that he has to make the payment, but and the it has to be paid within certain due date, and if not paid, then there will be interest upon it. Okay, so there will be certain loss to happening to the firm, right? The firm indemnify the firm for any loss cost. So anyways, the payment has to be made. So if suppose that interest incurred because he willfully, but it should be willful neglect. Okay, he intentionally willful, it's not unintentional. So he has willfully neglected in the conduct of the business, and because of that the firm has incurred loss which has to be borne by that partner. That partner has to indemnify the firm. But suppose if I say that if the firm has given certain stock to sell, uh, wherein the partner has tried it to sell it, but in the usual course of business, but couldn't able to sell it. So and because he couldn't able to sell it, the no lifespan has been decreased, and because of which the quality has of that product has been decreased, or might be it is perishable nature, and that it has because he couldn't able to sell it, it perished. So again the firm has incurred loss because of this. So do you think it will fall under this point?
Yes, ma'am.
Okay, but is it a willful neglect, whether he has not tried it or he has tried to sell?
No, ma'am, it won't be willful actually. I think this is unintentional.
Yes, so he has tried it but he unable to sell it. maybe that time he was matlab like everybody is not interested in the no market to buy that product, and he has given his effort to sell it, but he couldn't able to sell it. So in that case, it is a normal loss to the firm, and not because of his willful neglect, and he will not be responsible to indemnify the firm. Okay, the property of the firm. Subject to contract between the partners, the property of the firm. See, this section is going to say that what are the properties of the firm. Okay, first is your all property and rights and interest in property originally brought into the stock of the firm. So, during the conduct of the business, whatever the property is brought into the stock of the firm, that would be, or at the time of forming the partnership firm, whatever has been brought into the stock of the firm, okay, or acquired. So after no after becoming the after formation of the partnership firm, they have acquired certain assets, or a certain stock. So those are also the property of the firm, by purchase or otherwise, by or for the firm, or for the purposes and in the course of the business of the firm, and includes also the goodwill of the business. Okay, this acquisition is how the entire statement says about how the acquisition has been made. So it might be by purchase or otherwise, by or for the firm, or for the purposes and in the course of business of the firm. This is about the acquisition, how the acquisition has been made, and it also include the goodwill of the firm. So there is three kind of property here we are saying about, what is brought into the stock of the firm, what is acquired, and the third is about what is goodwill of the business. So these three are the property of the firm. Okay. So unless the contrary intention appear, property and right and interest in property acquired with money belonging to the firm are deemed to have been acquired for the firm. So okay. So what it is saying that any property which has been brought or acquired from the money which is belonging to the firm, that is the property of the firm only. Okay, and not of uh, and unless the contrary intention appears. See, this is also very important. So suppose a partnership firm has brought a laptop, okay, from the money of the partnership firm itself, but but all the partner has cumulative intention of not buying it for the firm, but for specifically for one partner. Okay, so if the intention is different, then it is not the property of the firm. But if there is no such intention and they just acquire the property, suppose that this laptop from the money of the firm, then it is obviously the property of the firm. Okay. Now if I say you an example, say ABC, all these three partner have a premise, they are all three brother also. Okay, so they have one property uh, on which they started a business. Now earlier they used to live that in they also used to reside in that premise itself, but when the moment they decided to do a business, to carry on the business there, they moved their family to another place, and the entire premise is used for carrying on the business only, and not for any other purpose. And this practice is continued for say 5 or 10 years. So after that, one partner died. Now the son of that partner is claiming right over that property. So do you think that is the partnership property, or you think it is not a partnership property?
Ma'am, can you please repeat the scenario once more?
So say if I'm saying that ABC being brothers, and they decided to carry on certain business in one premise, and they need a premise. So they where the premise wherein they used to live together, they used the same premise for carrying on the business, and they moved all their every brother has moved their all family to another place, and they have no, all the personal belonging has been moved from that premise, and for continuous 10 years that same property has been used for your carrying on the business only, and the business is still running, but one partner, say one brother or one partner, has died. Okay. And after upon death, the son of that partner, that no uh, brother or partner, you say, is claiming right over that property.
Ma'am, that is not possible because firstly, there was an intention to start a partnership business.
Yes. So that premise has been given to a partnership firm, and this has been reflecting through the conduct, right?
Yes,
That
ma'am.
that they have given this property to a partnership firm. Now this premise is not is not an individual property, but rather it is a property of a partnership firm. So upon the dissolution only, this the partnership, this property will be shared between the no partners, like the example which I have given you in the Indian Contract Act. But not no if they are continuing, if in the agreement itself it is mentioned that upon the death also the firm will not be dissolved and it will continue with the remaining partner, then in that case that premise is still the partnership firm property. And even if upon the dissolution, suppose this agreement is not there in between them, so even upon the dissolution also, this is again shared as a like partners share, and not as a no it will be considered as a partner asset has been shared between the partners, and not as the way the right over the ancestral property, that will not be considered as, because it is a partnership property. Okay, let me share one screen with you. Please go through it and give me a minute. Meanwhile, I'll come back. Okay. Any query on this?
Ma'am, the second statement, ma'am, how like the mere fact that property of partner being used for the purpose of firm shall not itself make it partnership. I could not understand why it not be a partnership property.
No, no. Unless it is intended to be treated as such. So suppose if
Okay.
this is very much important line, unless it is intended to be treated as such. Suppose in the same example, they have that person, like all of them has made had a clear intention that this premise is not for the business, it is for the temporary purpose. Okay. And they are using it for a firm, but for the temporary people purpose until they will find out another premise. Okay. So if they are not treating it like, since they are using it for the purpose of firm, that doesn't make it for partnership property. But if, unless it is intended to be treated as such, so if, since they are not intending it to be treated as such, hence it is not a partnership property. But if they are intending it to be treated as such, because for the continuous 10 year they are including it in the books of account, they are mentioning it as a property of the firm. There are multiple layers we have to see that how they have treated. Okay. Like intention, conduct, books of account, whether they have shown it as an asset of the firm. Okay. From whose money that has came. Suppose if it is from the partnership firm, that money, that property has been bought, or whether it is in the course of business, like they are treating it as a property of the firm. Okay. So all these things will be looked into. So this is very important, unless it is intended to be treated as such. Okay. Partners may be by agreement convert. So maybe they have mentioned that okay, it is for a temporary purpose, but later on they have converted it as a partnership firm property. Okay. And even if when after converting that property, they decided to separate that property from partnership firm to any of partners. Okay, that is also possible. Okay, so about goodwill, it is, see, so goodwill is not defined in the act, but it is basically anything which is earned above when the proper when suppose the asset, the entire value of the firm is say 1 crore, but because of the value, because of the reputation of the business, the seller is agreeing to buy it in 15 crore. So this 14 crore is your goodwill amount. Okay. So in general parlance, the definition is value of reputation of business house in respect of profit expected in future over and above the normal level of profits earned by undertaking belonging to the same class of business. So why that person is paying you extra amount? Because he's thinking by no taking over this business, he is going to recover. He's going to earn more amount from more profit. He's expecting in future. Okay. So if nothing is mentioned in the agreement, then the goodwill amount is also distributed between the partners. Okay. And any partner may, upon the sale of the goodwill of the firm, make an agreement with the buyer that such partner will not carry on any business similar to that of the firm. So whoever is purchasing that goodwill, he as it is not a restriction to trade, like as it mentioned in section 27. So but it has to be reasonable restriction. Okay. The person who is buying the goodwill of the firm, he may restrict that the other partners, to all the partners, that he will not, they will not carry on the same business for a specified period or within a specified local limit. Okay. And that will not be no, violating your section 27 of Indian Contract Act. However, such restriction should be reasonable. That person should not be restricting that in the entire world you will not able to, you will not able to do the same no business, or which is very unreasonable. Okay. This is what application of the property of the firm, it should be held and used by the partner exclusively for the purpose of the business and not for the personal purpose. Personal profit earned by partners. So if see, uh, there is two kind of thing in this also. One is any transaction of the firm. If a partner derives any profit for himself from any transaction of firm. So say if I am saying about the same example, from the trading of diamond. So from that trading of diamond, it is an any it is a transaction, normal day to day transaction of the firm. And in that if one partner no in, has recorded that he has sold 3 diamond, but he has sold 5 diamonds. So that that additional 2 diamond which he has sold, he has kept the profit of that, the sale price of that 2 diamond in his own pocket. Okay. He has not accounted that. So it, what is this? This is a secret profit, right? Or from the use of the property or business connection of the firm. Business connection is like, suppose this the customers. So if since they are into a diamond dealing, so they are selling to a particular, they are selling to their customers, and to same customer, that partner is also doing any business using that business connection of the firm and making the profit. Okay. Or the firm name, or by the using, by using the firm name, if he is making any kind of no profit, then he shall account for that profit and pay it to the firm. So he has to inform that profit to the partnership firm, to all partners, and pay it back to the firm. If a partner carries on any business of the same nature as competing with that of the firm, he shall account for and pay to the firm all profit made by him in that business. So here he is not using any, no any, he is not using any property or business connection or firm name, but he is just doing the same nature of business, like the diamond business. So since he is doing the same nature of business which is competing with that of the firm, he has to return it back to the firm. Okay. Rights and duties of partner after change in the firm after the expiry of the terms of the firm and where additional undertakings are carried out. So this you can go through. It is about the reconstitution of firm. Basically it is saying about that after the reconstitution of the firm, if nothing has been differently agreed, then the same rights and duties will will continue. Okay, please go through it uh, later. Relation of partners to third parties. Section 18, partners to be agent of the firm. So this we have already discussed that partners are agent of the firm and bind each other's. Section 19, implied authority of partner as agent of the firm. So what do you mean by implied authority?
Ma'am, like there is a mutual agency, so there is like an implied authority among the partners.
Yes, means that is inherent, implied. When we are reading about that in your condition warranty, we have discussed implied, no, and expressed terminology there. So that those are inherent. So it is not required to be expressed. If it is, even if it is not expressed, then also these are the inherent authority of the partner as agent of the firm. Like if they are into a trading business, so buying a stock, selling a stock is a inherent authority of a part with the partner, right? Borrowing money for the no, giving stock on credit, or your doing a bank transactions, those are inherent authority of the partner. So that's what it is mentioned, that which is done to carry on in the usual way business of the kind. So of suppose if they are business of, if they are into a trading business, but what they are doing, they are all the partners, what they do, they take money on a lesser rate of interest and then give it to somebody else at higher rate of interest. So in trading business of say rice, that is not the usual business, right? So this is not allowed. This is not the inherent authority with the partners. But anything which is done during the inherent authority of the partner, with that they, all of them are bind, and the firm is also bind by that. The authority of partner, this is what they can do. But in 19 subsection 2, it says what they cannot do. Okay, the authority of partners to bind the firm conferred by this section is called implied authority. This is what the section 1 says, 19 subsection 1 says. Now, subsection 2 says that in the absence of any usage or custom of trade to the contrary, the implied authority of partner does not empower him to submit a dispute relating to the business of the firm to arbitration. Any partner cannot submit it to the arbitration by themselves. Okay, so if they want to, then all the partners has to agree upon it. Open a bank account on behalf of the firm in his own name. They cannot do it in his own name, it should be in firm name. Okay, compromise or relinquish any claim or portion of a claim by the firm. So this also they cannot do it. Any partner can do not do it. This is again consent of all partner. Withdraw a suit or proceeding filed on behalf of the firm, admit any liability in suit or proceeding against the firm, acquire immovable property on behalf of the firm, transfer immovable property belonging to the firm, enter into a partnership on behalf of the firm. I hope it is clear. Okay. Extension and restriction of partner implied authority. So it can be through an agreement. This implied authority can be extended or can be restricted also. Okay, so suppose the if I say that a person in a trading business, they buy stock in credit. So if there is a any amount can be bought, any amount of stock can be bought in credit, right? But if the implied authority is restricted and it has been mentioned that only 50,000 rupees of credit amount of stock can be bought by Mr. A, and this information is also aware with the third person, then in that case the firm will not be bound by the act. If Mr. A is buying 70,000 of stock, the firm is only bound with 50,000 amount and not the rest of the amount. So firm will only pay 50,000, not the 70,000. But if the third party is not aware about it, then in that case, the firm will be bind with it. Or if I can say that if the third person has given that 70,000 stock to A, not knowing that he is a partner of ABC firm. Okay, so even as when he's uh, person is giving the stock without knowing him as a partner, then whether he's aware about the restriction clause, not restriction clause, that doesn't matter, right? The firm will not be bind with that transaction because he has breached the amount of 50,000 limit. So this is what it is written. Notwithstanding any such restriction, an act done by a partner on behalf of the firm which falls within his implied authority bind the firm, unless the person with whom he is dealing knows of the restriction or does not know or believe that partner to be a partner. So you go through it, you will understand again. Okay, if you will not, then we can discuss it in our next class. Partner's authority in an emergency. This we have discussed mostly. Mode of doing act to bind firm. Okay. In order to bind a firm, an act or instrument done or executed by a partner, other person on behalf of the firm shall be done or executed in the firm name in any other manner expressing or implying an intention to the bind the firm. See, usually all the things which from which you want to bind the firm, it has to be done in firm name. Okay. Effect of admission by a partner. So this also we have discussed that if it is made in the ordinary course of business. So basically any kind of no any this you have to connect. Wait a minute. This clause and this clause. Sorry, this is not the. This is a task. It it is a research task. What here it is saying that the person the partner is not having implied authority with regard to admit any liability in a suit or proceeding against the firm, and here it is saying an admission or representation made by a partner concerning the affair of the firm is evidence against the firm if it is made in the ordinary course of business. I give you a hint that here it is mentioned in the ordinary course of business, and here it is mentioned uh, in a suit or proceeding. Okay, and then understand what it both saying. Okay, here this admission is binding the firm in the ordinary course of business if it is done in the ordinary course of business, but here this admission of any liability in suit or proceeding is not binding the firm. So try to understand this further. Okay, so this is saying that effect of notice to acting partner. So if there is in an example where Mr. A is the only active partner and B and C are sleeping partner, so if any notice is given to Mr. A, it will amount to the notice given to all of them. Okay. Notice to the partner who habitually act in the business of the firm or any matter relating to the affair of the firm operate as a notice to the firm, except in the case of a fraud on the firm committed by or with the consent of that partner. So uh, if that diamond example itself, that uh, the seller has already informed Mr. A that this is of inferior quality and let's make uh, uh, have a deal that we will buy we use no the B and C will be not aware about it, you not inform, and we will distribute the difference amount. Here the here that Mr. A is already aware of. So even if the A is already aware about, it will not constitute as a notice to the firm because he is doing the fraud. Okay, except in the case of fraud on the firm committed by or with the consent of that partner. I hope it's clear. Liability of a partner for acts of the firm. Every partner is liable jointly with all the other partners and also severally for all acts of the firm done while he is a partner. So whenever there is a question came in your examination about mutual agency, then include this section. also. Okay, they are jointly as well as severally liable. So it means that the third party can ask the entire amount from Mr. A only, and not necessary it has to be asked from all of them, right? So they are they and since that is about severally, and jointly, that whatever the amount Mr. A has paid, they all are liable with regard to that. uh, Liability of the firm for wrongful acts of the partner. This also, you, I think you go through it, you can able to understand. 27 also, liability of firm for misapplication by partners. So it is basically that any amount the partner has received, and the partner has no any like, see, a partner acting within his apparent authority receive money or property from a third party. So this important word is apparent authority. So he has the authority to receive that amount, and he misapplies it. A firm in the course of its business receive money, or the firm receive that money in the course of business from third party, and any of the partner misapplies it, the firm is liable to make good the loss. Who is liable to make the good the loss? To whom? The firm is liable to make good the loss to third party, because suppose no, a third party has given this amount, say 1 lakh rupees, for and given a future order, um, once certain goods came to your premise, then, or it is ready, then you will transfer, you will provide, no, you will deliver it to me. Now this 1 lakh rupees is already received as a value for that transaction, and since the partner has misapplies it, now the firm is liable to make that good the loss. The firm has to deliver that good to, no, that whatever the order the firm has taken, or the partner has taken, that has to be delivered it to the third party. Or similarly, the firm has received the money, and any of the partner has done this, then also the firm has to make good the loss. uh, am I audible? Internet connectivity was gone. So
Yes, ma'am.
yes, 28, I think you can all go through it. Right of transfer of partners interest, minor admitted to the benefit of partnership, this we have discussed. In this, only thing which you have to know about it is that your minor, no within 6 months, once he becomes major, he has to confirm to the partnership, to all the partners, that he wants to continue as a partner or not. If he no agree to continue as partner, then in that case, all the liabilities will be, no, rights and liability will be with the minors from the beginning. But if he want, just give me let me share that this. Okay, on attaining majority, he can decide within 6 months whether he would continue or not, and give public notice of his decision. This is very important, public notice. Okay. Uh, Otherwise, he will be liable for debts with retrospective effect. So, first of all, he has to decide, and that decision has to be also be notified to public. And if he has not, then he will be liable for debts within respect with retrospective effect. Because if he has not no given a public notice, then he will be amounted as a partner, like after becoming a major. His share in the profit and profit of the firms shall be liable if he chooses to be a partner. His share of profit shall remain the same. A minor who attaining majority decide to become a partner is liable for all acts of the firm done since he was admitted to benefit of partnership. This is very important, that if he continue with the partnership, like after becoming a major, if he wants to be continue as a partner, if he wants to be a partner, then in that case, all the liabilities or all the acts which has been done when he has been admitted as for the benefit of partnership, from that time onwards itself, he will be liable for all the acts of the firm. But he will not continue with as a partner. Then in that case he won't be responsible. But if he has, after becoming a major, if he has not given a public notice, then also he will be constituted itself that he becomes a partner. So that decision has to be communicated. Okay, section 31, it is about introduction of partner. So any introductions which happen to no any kind of admission happen, it should be always with all the consent of all the partners, and not otherwise. However, by express agreement, again, that criteria can be also changed. That's why it is mentioned that subject to the contract between partner and to the provision of section 30, no person shall be introduced as partner into a firm without the consent of all the admitting partners. And the admitting partner will be responsible for only new liabilities, any of the acts which has been done before the before its his or her admission. Retirement of partner. So a partner may retire with consent of all the partner. This is important. Again, in case of retirement, the notice of retirement has to be given to all the partners in accordance with an express agreement by the partner, or where the partnership is at will, by giving notice in writing to all the partners of his intention to retire. Okay, so basically it should be given to all the partners. So now if I give you in a situation wherein for a retirement, what the partner has suppose Mr. A want to retire from partnership, and instead of giving a notice, he filed a suit in a court to dissolve the partnership firm, because retirement also amounts to dissolution of the partnership, right? So so the partners given a defense that the for the purpose of retirement he has to give a notice to all of the no partners, and with that consent only he can retire. So the court in that scenario, the court held that the summon which is given by no when he filed a suit, the summon has been provided to all the partners of the firm, and that summon will considered as a notice. I think we have discussed mostly about the retirement part. That upon retirement, he has to give public notice to all the to third parties, and if he has not given, then he will be responsible for all the liabilities. This clause you can see, provided that a retired partner is not liable to this one, not to any third party who deals with the firm without knowing that he was a partner. So for that, he will not be liable. So suppose if the after Mr. A's death, or say after Mr. A's retirement, B and C is dealing with the third party, and the new that is a new new seller, say, given certain stock to that B and C without knowing that A was retired, or without knowing that whether A was being a partner in that. So he is dealing with B and C. So in that case, the retired partner is not liable. In expulsion, insolvency, these things, please go through it. I think these are self-explanatory, and if it required, then we will discuss it. Okay. Dissolution by a notice of partnership at will. Where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all the other partner of his intention to dissolve the firm. Okay. The firm is dissolved as from the date mentioned in the notice as the date of dissolution, or if no date is so mentioned, as from the date of communication of the notice. What it is trying to say that, in case of partnership at will, if the partner wants to dissolve that partnership, he has to give notice to all the partners. Okay. And such and in the notice, if particular date is mentioned as a date of dissolution, then that date will be considered as date of dissolution. But if no date is mentioned, then it has to be that then all the partners receiving the information, receiving the notice, uh, that the last partner who received that notice will be the date of dissolution. Okay. We'll be discussing about registration now. Before I start with that, reconstitution of firms, if see, whenever, why we are saying that reconstitution of firm, because after this, after suppose any kind of any new member introduced, or any retirement is happening, or expulsion of partner is happening, or insolvency of partner, or death of partner is happening, in that case the firm can either be dissolved, or the rest of the partner may no constitute the firm. So that will be a reconstitution of firm. Okay. So please go through these sections, and then we will see that if discussion is required. The important thing is, unless otherwise agreed by partner, as a continuing guarantee given to a third party by the firm is revoked as to the future transaction from the date of any change in the constitution of firm. So suppose if in case of reconstitution of firm, that continuing guarantee also be no will not continue, it will be revoked, uh, only for the future transaction, and not for and whatever the liability has been there for the previous transaction, that will remain. And the rights and duties of the partners of the reconstituted firm shall be also same, if until unless they have changed any terms and condition. Okay. And till now we have discussed about right of partners, act within implied authority of partners. So what are the acts within implied authority of partner? We have discussed that purchase of goods, sales of good, any kind of settlement of accounts, or the person or partner can receive the payments, engage lawyers, engage servants, borrow money or for the firm. Okay. Your place the goods for the firm as security for repayment of borrowing made for the firm business, draw, accept, endorse bill of exchange and other negotiable instrument. These are usually an implied authority of the firms, which the partners can do, right? And we have also discussed rights of partners, like take part in the conduct of the business, expressing their opinion, access to and inspect and copy of any of the books, interest on capital or advance, share profit and property, to be indemnified. Okay. Again, not to be expelled unless majority partner agree and provision to that effect exist in the agreement, register the introduction of new partner, right to retire, right of outgoing partner. So if you will see that, you can go through this also list. So basically I have just bucketed what we have studied till now. So you can see that these are just in exam usually what happen, the question will be coming, what are the rights of the partner, what are the duties of the partner, what are the act within the implied authority of the partner. So what we have read in the barrett, this only I have just bucketed in this box. So if you go through it, you will find the same pointers here. Okay. Acts beyond implied authority of partner, this I have mentioned that the firm is not liable to a third party for the above restricted acts of a partner, whether or not the person dealing with the firm know about such restriction. So this is again mentioned in your act itself. So just try to bucket it like this so that it will be easy for revision. Now, do you think registration of partnership is mandatory, or it is optional? What the law says about it?
Ma'am, it is optional.
Yes, it is optional, but but if you go through section 69, you will find that though it is an optional, but law intent or push it to no partner to partnership firm to go for a registration, because the kind of benefit registration provided, non-registration will not provide you. So like in case of if the firm is non-registered, then the partnership firm cannot sue third party, neither the partners of the firm can sue firm. Okay, so this is a very no negative for a firm, that if anything wrong happened, then the partnership firm cannot able to sue any third party for that wrong, but the third party can sue partnership firm. Okay, or partners of the firm. So it is mentioned as no suit to enforce a right arise. See, when I say I'm saying the third party can sue to partnership firm, it means we have already given order 21 or that CPC sections order I have provided to you. Therein itself mentioned that when we are saying partnership firm, it is about the partners. When the part when they are no when any suit happen, it is the partners cumulatively responsible, because there is no separate identity of partnership firm. Okay, I hope you have gone through CPC order 21 rule 50 and CPC order 30 rule 1 again. So no suit to enforce a right arising from a contract or conferred by this act shall be instituted in any court by or on behalf of any person suing as a partner in a firm against the firm. So partner cannot sue firm or any person alleged to be or to have been a partner in the firm unless the firm is registered and the person suing is or has been shown in the register of firm as a partner in the firm. Okay, so again, uh, basically it is mentioned these points only, that the partners cannot sue a firm, and the firm cannot sue third party. However, the third party can sue firm, and they cannot the partnership firm cannot claim for set off not more set off for not more than 100 rupees of amount, and third parties has a lot of rights against the firm, but since it is not registered, so the firm is having a lot of restrictions with regard to that because of non registration, right? But any criminal suit has to, if any kind of no, but the partners can sue for criminal proceeding against the other partner of the firm and against the third party. So when we are saying about the partner or firm cannot sue third party, so it is about similar civil proceedings and not for the criminal proceedings. Okay, and any other questions you think, or any other because of non-registration, you think any other restriction would be there with the partnership firm? These three are only there, that partner cannot sue your firm or other co-partners, or the firm cannot sue your third party, and they cannot claim set off or other proceeding based upon the contract more than 100 rupees. These are the three which the firm cannot do it because of non-registration. But the third parties has right, even if the firm is non-registered, like third party can sue the firm or any partner. The official assignee or receiver or the court has a right power over the firm, like in case of insolvency, the official assignee can be appointed or receiver can be appointed. Okay, the partners can ask for dissolution, or can ask for accounts of the accounts of the firm, or realization of property, that those things are will be there even if the firm is registered or not registered. Okay, and the rights of the partner to sue for criminal proceeding against other partners or partners, third party, that will be also there. So these are the things which in case of non registration, the firm can't do and the other can do. I hope I think we have prima facie went through all the provision, and I want you all to go through the entire barrett, and then if any queries left, then we can discuss.
Yes, ma'am.
With regard to any previous class, any queries is there?
Ma'am, last class you had told to go through section 74. So, ma'am,
Hmm.
I read it and I found that Partnership Act is only applicable retrospectively. Previously, whatever contracts have happened, partnership contracts have been happened, it will not apply on those previous existing ones before this act.
Yes, so it is prospective, and there is a saving clause wherein those areas will be saved. So
Yes,
it is
ma'am.
not going to impact that. Okay, fine. Thank you, Ananya. Thank you all. I hope we'll be moving. If no queries will be there in with regard to partnership, then we will close the Partnership Act and we will move to non negotiable instrument. And if any queries will be there, then we will take another session. Please inform in the group itself. So accordingly, we will decide for another session for Partnership Act.
Ma'am,
And
so far I don't have any queries, but I have asked you one question on email, so please, if you can reply to it.
yeah, sure, Ananya. I will go through that. I think I missed that. I will just look into it and I will respond to you. Okay.
Yes, ma'am.
Thank you all. Good night.
Thank you, ma'am.